What is undue influence and what can you do about it? Hi, I'm attorney Paul DeLaurie, and I'll answer that question in 3 steps. Step 1, let's define undue influence. In simple terms, undue influence occurs when someone exerts excessive pressure to sign a legal document, such as a will, trust, or maybe a deed to a house. That pressure significantly impacts the person's decision-making ability. It's like having a puppeteer pulling the strings behind a decision that should be personal and voluntary. Recognizing undue influence can be tricky. It often happens behind closed doors. Some common signs include isolation of the person, where they're cut off from family or friends, sudden changes in estate plans, especially if they now favor one person unexpectedly, unusual involvement, where one person is overly involved in the process of creating the legal document. Undue influence isn't just about someone saying, "Hey, leave me your house and your will." It's subtler and often more insidious. It might involve manipulating a vulnerable person, exploiting a position of trust, or even isolating the person from their family or friends. The key factor? The influencer gains an unfair advantage. Now, the law takes undue influence seriously. If a will or trust is found to be the product, or other document, is found to be the product of undue influence, it can be declared invalid, and this protects the true wishes of the person who signed the document. Step 2, figure out if there's a presumption of undue influence. In Arizona, a presumption of undue influence typically arises in specific circumstances where there's a combination of a confidential or fiduciary relationship and suspicious circumstances surrounding the preparation and execution, signing, of the document. This might include situations where the beneficiary had a significant role in preparing the document, or if the person signing was in a vulnerable state, such as having diminished mental capacity, and the terms of the document disproportionately benefit the person in that confidential relationship. The key elements for this presumption to come into play include existence of a confidential relationship. Now, this includes a relationship where trust and confidence are placed by one person in another. It could be a legal relationship, such as guardian to the ward or conservator to a protected person, but most likely we see it being a personal one, like a caregiver to the person being cared for. The second element for the presumption of undue influence to arise is active participation in procuring the document. The person benefiting from the document played an active role in its creation or signing. This could mean that they helped draft the document, they chose the attorney, or were present when the signer expressed their wishes. The third element for the presumption of undue influence to arise is the benefit, the undue benefit. The person in the confidential relationship receives a substantial benefit under the document, which seems unusual or unexpected given the history and nature of the relationship. Now, when these factors are present, there might be a shift in the burden of proof. And this is very powerful. If you're trying to prove that there's undue influence, if you can shift the burden of proof, now the person that you're accusing has to come forward with evidence and show that there was not undue influence. Okay, the person accused of exerting undue influence may need to prove that the influence was undue, like I just said. However, it's important to remember that in each case, the facts are unique, and the facts and evidence will play a crucial role in determining whether undue influence occurred. Step 3, have a probate litigation attorney analyze your situation from a legal standpoint. In determining whether excessive influence was used, the courts look at all of the circumstances. Generally, the courts will focus on the following factors. Did the influencer lie to the person signing? Second, was the document prepared and signed quickly without deliberation or consideration? Third, was the execution of the document hidden from others, such as family members? Fourth, did the person who benefited by the document participate in having it drafted and signed. Fifth, was the document inconsistent with prior plans? Sixth, was the document unreasonable in view of the signer's circumstances, attitudes, and family? Seven, was the signer vulnerable? Did they have a medical or mental problem? Were they able to get out, or were they reliant on the on the caregiver or whoever exerted the undue influence? And then, did the signer and the beneficiary have a close relationship? If you can make a case for undue influence, the next step is to file a petition with the local court to have the document invalidated and any money or property returned and given to the appropriate persons. Of course, not all influence is inappropriate. To be undue, the influence must arise to the level where the influencer causes the person to disregard his or her own desires and instead follow the directions of the influencer. If the document was adopted because of undue influence, it generally can be canceled, or the gift to the influencer can be set aside. If you have any questions about whether a document, a will, trust, or deed, or any other document can be set aside based on undue influence, or maybe for other reasons such as fraud, lack of testamentary capacity, forgery, or if you have any other questions, give us a call at 602-443-4888 or send us a message through our website. Thanks for watching.